and welcome to the Max Weber interviews. We are delighted and honored to have Professor Reva Siegel here with us today, who is Nicholas Katzenbach Professor of Law at Yale Law School. Professor Siegel is one of the most prominent and influential legal scholars in US constitutional law. Much of her work addresses questions of constitutional interpretation and decision-making, with a special focus on race equality, gender and religion. Professor Riegel's recent work explores how constitutions structure conflicts in disputed topics, such as same-sex marriages, which will also be the topic of today's Max Weber lecture. Thank you very much, Professor Siegel, for being here with us today. And let me start with the first question. In your recent work, you claim that political and personal objections in ethically controversial topics, such as same-sex marriage or abortion, are increasingly framed as conscience claims. Where do you think lies the novelty of this development, and how does it affect the public discourse on these topics?
So, in the United States and to a certain extent in Europe, I'm still investigating the degree of this connection. There are debates over so-called culture war topics. We certainly expect to encounter in public conversation debates about abortion, and often people take sides in ways that link abortion to issues of gay rights or same-sex marriage. And if one thinks about it, it's not entirely clear what the connection is across the topics, but one could think about the issues as arising out of contested or non-traditional understandings of sexuality. Non-procreative sexuality is sometimes a way in which the topics are understood and linked in religious doctrine in the Catholic Church, but also in other Orthodox faiths. So we know that these debates exist, and we know or encounter familiar languages in which they're argued over. But the language of religious liberty and of conscience has entered these debates in a degree. And how does that come to be the case? Often where the law recognizes, for example, the right of same-sex couples to marry or of access to abortion in whatever limited degree, persons who object to the law may seek an exemption from the law's application on the ground that whatever the law of general application, individuals who disagree with the way in which the legal system has resolved the question ought to have the liberty to be exempt from the law's application on grounds of conscience or religious freedom. And so these are demands for accommodation or exceptions to be made from the law of general application. And areas in which this happens is the area of healthcare, for example, where for example, if someone is dispensing contraception or providing access to abortion, providers may object to being involved with the practice. And it's now spreading into the areas of marriage law and anti-discrimination law, where the healthcare refusals have served as a model for similar claims for exemption or refusal on the part of persons who object to same-sex marriage. Sometimes the claims are on the ground, the exemption claim takes the form of, I don't want directly to participate, as in I don't want to be a physician involved in providing access to the service, or I don't want to be a clerk who's going to officiate over a same-sex union. And sometimes the claims are objections to being made complicit in what is seen to be sinful conduct. So I don't want to rent the room of my hotel to a same-sex couple. That's Bull versus Hall. It's a case in the UK. Or I don't want to sell various marriage goods to a same-sex couple because I don't want to be asked to sanction the relationship. It would make me complicit in what I believe to be a sin. So that's how the complicity claims get into the area. And they present an interesting conjunction, because the values that are funding the claim that there's a sin at stake look to be traditional views of sexuality, and yet the claim for exemption is a claim on pluralism. a claim for the respecting of individual rights to dissent and to deviate. And so it seems to tap a more liberal ideology. So it's not clear whether the objector is speaking as the majority or the minority. The two get confused together in a very interesting configuration. In my work, this is the last thing I'll say about this, I have tried to approach these claims as bona fide claims of faith, which nonetheless may be understood to differ in kind from other faith claims that we may accommodate in the following respect. When we accommodate someone who engages in a matter of religious practice, or someone who wears religious gear, for example, a headscarf, the practice that's accommodated does not refer to other members of the society. But what's distinctive, I think, potentially about these new claims in the culture war context is that they are claims that are aimed at other members of the polity, claiming that others who don't share the objector's belief are nonetheless sinners. And so they raise distinctive issues of third-party harm if we're not careful about the ways in which we consider and potentially accommodate them or structure the accommodation. And that's the kind of puzzle I've tried to put on the table. Even if they're bona fide faith claims, we still need to be careful that we accommodate or make decisions about accommodating in a way that genuinely defend pluralism in the sense of providing for the needs of believers and persons who don't share the believer's beliefs. So.
Okay, and following up on this topic, do you think that this developments towards framing the religious or ethical objections as conscious claims, and also maybe this majority blurring, might also be used in other constellations than same-sex marriages or abortion, the ones that you mentioned already?
Other contexts in which these conscience claims have already appeared are linked through the idea of privileging sexual expression for procreative purposes. So contraception is also a subject of conscience objection. In the United States, there's a case called Hobby Lobby that concerns insurers who objected to providing employees health insurance that would cover contraception. So it's a complicity claim concerning contraception. Assisted reproductive technologies is ART is another area where you can see these, and there it's non-sexual procreation is also a subject of these conscience claims. But I guess the second point to make about this is that I'm interested in the conversation in ways that range beyond the specifics of religious accommodation in the following sense. In my work on constitutional conflict in the United States, I'm really interested in the dynamics of debate and the evolution of arguments in the field of debate. And I've, in other of my work, looked at the ways in which objections to certain practices change in their form and their justification over the course of a long-running debate. So, for example, in debates over racial segregation in the United States, there were religious conscience objections in favor of segregation, and those gave way to objections from federalism and tradition. And now in debates over affirmative action, opponents of affirmative action use the language of equality to express their beliefs, so they talk in the language of colorblindness. So it's again a case where over the evolution of argument, a traditional argument will eventually don the garb of liberal values. You can see that in the abortion context as well, where now there's objections that abortion harms women. So people who are opposing abortion are speaking as feminists, and they're using the frames of pro-choice to talk about the argument for criminalizing abortion. So I guess I would say that I'm interested in the ways in which, under the pressure of debate, arguments can evolve over time.
You've also extensively written on race equality, and in particular with a view to the situation in the US and the jurisprudence of the Supreme Court. Based on your expertise, how would you see the situation of race equality in your country today? And what would you say maybe did the presidency of Obama change in this respect, if anything?
That's a huge question. Let's see if I can say a few things about it. I guess the first thing I would say is that American law did something quite ambitious and daring in trying to use the law to dismantle racial segregation. And both the Brown versus Board of Education decision and also American civil rights legislation, the 1964 Civil Rights Act and the 1965 Voting Rights Act, really tried to pry apart long-standing practices of racial separation and hierarchy. And in the effort to do so, they produced what I would call backlash. They produced much political opposition, and our law evolved in a way that sort of took elements of each side's arguments over time. And I would say that the struggle over the path of desegregation was so prominently a part of American politics for so long that it played a significant role in the appointment of judges to our courts, and eventually the election of presidents and the appointment of judges to the courts. And over the decades, our court moved in really striking ways in its approach to questions of racial justice. In one of my papers a few years ago, the Harvard Law Review has something they call the forward, and I wrote a paper called Equality Divided, in which I gave a multi-decade account of the evolution of American equal protection law in the passage of fighting over these issues, and showed how the law evolved from what I would call minority protective to majority protective. So that it's often the case now that our equal protection clause, which was once an instrument for dismantling racial segregation, is now not infrequently used as a restriction on civil rights laws. The court has struck down important provisions of the Voting Rights Act and has limited positive action law and has intervened in a way so as to limit civil rights initiatives in various ways. Before Justice Scalia's recent passing, I would say that the court was rather divided. It was 4-4 with Justice Kennedy divided right down the middle about what he thought about issues of racial justice, and so the law really wove an uncertain path. And I've also written trying to demonstrate the ways in which the swing justices on our Supreme Court in recent decades have not just endorsed colorblindness, not only limited what law can do, but have also allowed law that intervenes on behalf of minorities. I've tried to show how they've been concerned about social cohesion values, and for those reasons they've allowed legislative actors to intervene in a way that would reduce racial segregation, so long as the intervention didn't too greatly exacerbate racial polarization. So that anti-balkanization principle is one about which I've written on numerous occasions. Of course, we're now facing another appointment and another coming election, and we don't know in which directions our court will go, so we will have yet to figure out what will be the direction of the court's jurisprudence in these areas. About President Obama, I would say that he's a transformative figure. It's a first in so many profound ways for the United States. He's made an important difference, I think, in matters of racial justice, especially in the criminal law area. We're having great struggles over racial bias in our criminal justice system, which the courts have failed sufficiently to police for the reasons that I hinted at earlier. But he's also been limited, as the first African American president of the United States. He's been constrained in the ways he could act on behalf of minorities. As a first woman, for example, would be constrained in the ways that she might act on behalf of women's emancipation. So, he has critics from the African American community who complain that he hasn't done enough, and critics from across the aisle, as it were, who complain he does way too much and he's just endlessly subject to criticism. You can see backlash forces also in the direction of the American debates over the election forthcoming and in Trump's candidacy for president, in which much hostility to racial diversity is being expressed. So you can see something about the ecology in which he's had to govern. It's a very difficult path that he has to pursue, and he's a great man who's done a very amazing job in very, very, very rough waters.
Mm-hmm. Yeah, that was also the debate we had in Europe on Obama. But I want to go to another topic and address you also as a constitutional and law scholar more in general. So my question would be to your understanding of the US Constitution, and whether you think, and to what extent do you think that it is, as created in the distant past, to what extent it can be responsive to evolving social needs. We talked a lot about minority rights, etc., and to ideals of justice, and while at the same time sustaining its authority. And whom do you envisage as a guarantor of such a process? The legislature or the courts or someone else? Or a mixture of all?
So in the United States we have the situation of a constitutional text that dates back over centuries in significant parts, and it's a finite text, and so it's been the locus of much debate. Its meaning has been the subject of debate and evolving interpretation over the decades and the centuries. I one time wrote a paper about social movements and the dynamics of constitutional interpretation, which I called Text in Contest, and it sort of summoned the idea that there's this finite document whose terms are accessible to everyone and whose meaning is debated by everyone. And I would say that for this document to be law, it needs to be understood to have the fundamental qualities of law, permanent principles of law, but it also needs to be understood to be my law. The author of the document is we the people, and as I often say to my students, who are we? So that the subject evolves in history, and so the interpretation of the document needs to have a kind of intergenerational authority that ties past and present and future in important ways. And we have practices of interpretation that I think allow our debates over the Constitution to be both appealing to the fixity of text and the authority of history, and at the same time to be infused with debates about new problems and claims on new understandings of the Constitution's meaning. And this afternoon I'll be talking about the same-sex marriage claim, which surely was not one, as Justice Kennedy pointed out, was not one that was available at the founding of the Constitution. So I guess I would say, when I've written about this, sometimes under the rubric of democratic constitutionalism, I've said that we have practices of interpretation that combine claims on the Constitution as law and as responsive law, as evolving law. And that's so whether or not the interpreter is an originalist or is practicing so-called dynamic or responsive or living constitutionalism. All of the interpreters, including Justice Scalia, make appeals on history and appeals on the past, and sometimes they make appeals on precedent and text and in the service of their understanding of the best understanding of the Constitution. And I'd also add that it's the courts, the legislature, and also the mobilized people as well, who play a role in these debates.
And you've also worked extensively on equality rights and gender, while being a preeminent female legal scholar yourself. One aspect that is of interest to us would be also the situation of women pursuing an academic career. How would you, based on your experience, see the situation for women in this respect? Do you think that women are treated equally, or that there are still obstacles that women have to overcome?
So I think I would say that I think women are treated more equally, without saying they're treated equally. And that is to say, over the time that I've been in teaching. There's been enormous changes in the number of women in the profession and the ways that women can be in the profession. Whether it's women who are having children before they get tenure, that did not happen so much when I was coming up, but it's now more prevalently the case. Or it's women assuming positions of responsibility, being deans of law schools or that sort of thing. There's been, or just simple numbers of women, there have been these dramatic signs of change. But there are still ways in which the gender story matters. And sometimes it's about a question about the areas in which people are doing work. In constitutional law, there still aren't so many women as there are in other areas of law, I think. And you know, it just varies by field. I think that sometimes it's a subject matter question about what people feel comfortable writing on, or feel that they're free to write on and still be treated as a genuine and full participant in the practice, as opposed to getting minoritized or segregated. When we were talking earlier, I was saying that I personally of the view that no one should, people should choose. First of all, if people go into teaching, they should write about what they think really matters to them. That's the first point. The second point is, if women are concerned about these questions, they can make a practice of writing about more than one subject, and so that they're not just simply put in a bucket. But it would be a genuinely sad thing if women entered the profession and do have an interest in writing on issues of concern to women and feel they're not free to do so. That would be genuinely a problem. So it's certainly nothing that all women should feel that they're obliged to do or should have an interest in. But if they do, it would be a terrible thing if they allowed themselves to be silenced or censored for fear of being valued differently for engaging in the question. And so, I mean, in my own work, I've sort of woven in and out of topics, and sometimes I say, okay, I'll do this no matter what, no matter the consequences, and other times I'm perfectly happy to be and quite caught up and engaged in other questions of concern to me. So there's that, and I think that it's still an evolving enterprise in which we're still inventing what it means to be in the academy and to be in law, and it's for the next generation to continue the project. So.
Okay, thank you very much.
Thank you very much.